recount the unique history of this country. The judges did that. They looked at the Kriegler report and what it says, and to use the words of Chinua Achebe, to disown that history of this country, you must be a very dishonest person, you must be a liar, you must be fraudulent to disown that history, because we were all here. We know how Kriegler happened. We know how it happened. To disown it, you must be irredeemably bad. Having said that, my Lord, allow me in the next couple of minutes to address an issue that arose again yesterday about the continuum of this amendment process. Learned Senior Counsel, very good friend, very good mentor of mine, Senior Counsel Mutembei Amolo Paul, raised the issue of severing the process of the steering committee, the task force, and something called the secretariat. He said those were three distinct processes, and that when you retire, you must make that finding. When he made that submission, I was sitting far behind in this room, and I thought the judges must have had that in mind when somewhere in this judgment they say there's an attempt to amend this constitution by stealth. That we shall do it this way. When they ask us, we shall just say it is this way. Why do I say that, my lords? The person whom Paul Otiende Amolo wishes to convince you was the promoter of this bill, swore affidavits in the High Court, and you were taken through those affidavits in detail. I wouldn't want to do that because I don't even have the luxury of time to do that. But just a brief aspect that I would pick is to be found at page 2678 of the record of appeal filed by the Honorable the Attorney General. So when you go to page 2678 of that record of appeal, you will find the affidavit of Dennis Waweru. That name featured yesterday, as I've said. Turning over leaf, Dennis Waweru told the High Court in a sworn affidavit that, paragraph 5, my lords, I'll not ask you to take verbatim this because it's not necessary we find the record, but for the full effect of my submission, I'll take you through it. That the building bridges to a united Kenya was created. Who created it? Was created and mandated with the task of initiating a constitutional amendment process and unifying Kenyans, among other functions. That the Building Bridges Initiative Task Force and Secretariat, he now says they were one and the same functionaries, and Secretariat conducted a robust nationwide public engagement and collection of views on a wide array, including meeting professionals and professional bodies, among others. That upon receiving those views on various issues, it, which now refers to the Building Bridges to a United Kenya, same original entity, made various legislative, policy, and constitutional amendment proposals. Now, my lord, we are told to ignore this that we said on oath, that this was a continuum of a process. Because when you look at this judgment that is impugned, they are saying the judges of the High Court confused this to have been a continuum of a process. That's in a nutshell what they are saying. They themselves, on a sworn affidavit, are telling those same judges that same story, that this was a continuum, one continuous process on a sworn affidavit. And that's the person you are told that is actually the promoter. My lords, allow me to make one argument that my learned colleague, Ms. Angawa, made yesterday, and she asked me to cap it up because of the time constraint she served yesterday, that even if you, and I really celebrate the young, what we call young counsel who appeared here, because they have really proved that the future of the profession is safe. I must put that on record. Even if you are to believe my learned colleagues for the IEBC, that referendum in this context is governed by the Elections Act, even if you were to believe them, I'm sure following Ms. Angawa's submissions, they may consider departing from that position. But even if you were to believe them, you then see that the obligations in the Elections Act are such that the National Assembly, when it is faced with an issue that is supposed to go to a referendum, has an obligation to approve one or more questions. One or more questions. So that, how does the National Assembly approve one or more questions? It must consider whether it is a question worth going for a referendum. There must be a thought process applied to it. And you'll see later, as she submitted yesterday, that where there are more questions, there shall be a referendum committee for each question. For each question. That's what the statute that the IEBC is calling upon you to follow says. It follows, therefore, that if the Parliament, for example, has to apply its mind to the question before it, the issue that somebody has to keep running to court to get an interpretation every time, then going to consider whether is it not, cannot arise. My lords, I will submit to you that Parliament, for example, the Speaker of the National Assembly by law is prohibited from allowing debate on a motion that is unconstitutional by law. The Speaker cannot allow debate on a motion that is unconstitutional. It behoves me that you have not seen speakers coming to courts to ask you, is this motion constitutional, my lords, before they go back to Parliament to conduct debates. It means, therefore, that there is an element of scaremongering in telling me that you'll be overburdened, my lords, that people will have to come here. Truth of the matter is that every person who intends to amend this constitution has an obligation to apply his own mind on whether the amendment he proposes affect the basic structure or not. To apply his or her mind. Once he applies his or her mind, he proceeds accordingly. If a vigilant citizen takes the view that the manner in which that person has applied his or her mind is wrong, it is that person who approaches to court to challenge the process, as has happened here. Courts will sometimes agree with such litigants. Courts will sometimes disagree. So the argument that the judges here created a scenario where whoever wishes to amend the constitution must come to court does not pass muster. And I will submit to you by way of comparative reasoning that this applies in all spheres of our operations. I know for a fact that if I engage in a fraudulent land transaction, that land transaction will be nullified by the court. But that does not mean that people come to court to seek an interpretation first. Is this fraudulent or not? Before they engage in land transaction. They apply their mind to the question, to the principles first, then begin the process. It is whoever believes the process is fraudulent that comes to court. Allow me at this juncture, in our spirit of sharing time, to invite my learned colleague, Mr. Ogada, to pick over from there and do duty for the respective respondents. And thank you so much, my lords, for the opportunity.
Thank you.
Good morning, your lordships, your ladyships. I must start by paying homage to my seniors, ladies and gentlemen who have toiled and did service to the profession, though we sit on opposite sides. Particularly have to recognize the efforts and input of Senior Counsel George Oraro, decent gentleman in every sense of the word, Senior Counsel James Orengo, Gatonye, Martha Karua, all protocols observed, Alicia Ngoya, you have done well for us, and you have blazed the trail for us. In the spirit of recognition, I have to recognize my teacher, Professor Ben Mutembei Sihanya, who sits on the other side, representing the Building Bridges Initiative, and the Honorable Raila Odinga. And I will recall Professor Sihanya for not only being a great teacher, but also for the manner in which he dispatched me to the world of the profession and into the world of work. This is what Professor Sihanya told me and my colleagues, ushering us into the world. Go ye, people of Jerusalem, as he called us, and speak the constitutional truth. Speak truth to power. Professor Sihanya, I can assure you that I am here to speak the truth, and I will speak the constitutional truth to the following questions relating to boundary delimitation and review. The appellants have raised certain questions with regards to the decision of the High Court, and certain issues have been raised with regards to the people and sovereignty. Certain issues have been raised with regards to the authority of the High Court. And most particularly, there have been raised concerns with regards to public participation. Judge President Musinga, you posed a question yesterday. Who are the people? I will attempt to proffer an answer. The people as a constitutional construct, and indeed the term the people is a continuous theme under the Constitution. Where do we find the term the people under the Constitution? The preamble, paragraph 2, Article 1 of the Constitution, Article 94(1), Article 129, Subarticle 1, Article 159, Subarticle 1. That is not an exhaustive list, but those are the salient examples. Now, the term the people was bandied by the appellants to show that the court, the High Court that is, usurped a power belonging to the people. In doing that, the High Court was faulted for ignoring the popular initiative, an initiative of the people, under Article 257. And in any case, the High Court was faulted for stopping the people from accepting or rejecting the Constitutional Amendment Bill at a referendum. In examining the concept of the people, and we refer to the people at paragraph 2 of the preamble, Article 1, Article 94(1), 129(1), 159(1), we submit as follows: that the Constitution knows of a distinct and graduated schema of the term the people and or authority exercised by and on behalf of the people. We want to make reference to the following. Volume 7 of the Attorney General's list of authorities in appeal, at page 2645, contains the submissions of the respondents, Justice Juma and Isaac Ogola, in the High Court. And specifically, I want the courts to examine paragraph 21 of the main text, which is referenced in the footnote at paragraph 30 of the same page, a text entitled Yaniv Roznai Amendment Power, Constituent Power and Popular Sovereignty, Linking and Amendability and Amendment Procedures. This is in the edited text by Richard Albert, Zenon Contrades and Alcamen Fatidu. That was by the respondents here, the petitioners in the High Court. That argument was so persuasive that the Attorney General decided to adopt it in appeal. And the Attorney General, at paragraph 44 of their submissions, adopts the graduated power scheme in the Constitution. What is this? What did the Attorney General say at paragraph 24? For quick reference.
24 or 44?
44. It is the Attorney General's further submission, they said, that the people of Kenya, in the exercise of their secondary constituent power, are at liberty to amend the Constitution without resorting to the primary constituent power and provide changes, provided that changes are done in accordance with the provisions of Chapter 16 of the Constitution. What are the distinct and graduated schema the term the people denotes under our constitutional scheme? Primary constituent power. Paragraph 2 of the preamble. The primary constituent power is not bound by constitutional rules. It exists outside the constitutional rules. It acts only when enacting a new constitution. B, the people in the secondary constituent sense. The people acting to amend the constitution. The people acting in the course of an amendment process. Those are the people in the secondary constituent sense. Then we have a third tier, that is the constituted constitutional organs, where the people can be involved in terms of influencing decisions. So we have constituted organs as a place where the people can exercise their sovereignty. Constituted organs include the judiciary, the executive, and of course the legislature. Now, we have to make a connection between the people and the concept of sovereignty. Due to the urgency of time, the term sovereignty is understood as residing in the people exclusively. What is understood by sovereignty? Sovereignty manifests majorly in two forms. I want to refer to you in paragraph 2, in page 296 of the respondents' bundle of authorities, page 296, paragraph 224. There's an article there by Dieter Grimm, whereby sovereignty, first and foremost, is political rule. Supremacy, political rule. Sovereignty also can denote legal power. That is in the same book, paragraph 30. The power to create is on. The referendum. We submit this, that the referendum is a tool of involving the people to affirm a decision or to influence a decision. It is in democratic theory called a mechanism for direct democracy. It affirms a process. The referendum, when used in the context of making a constitution, it will be exercised in the primary constituent power. However, a referendum exercised in the process of amending the constitution, such as in our case today, within this litigation, is going to be exercised within the secondary constituent power. That distinction is important for this, that whereas the court did not and cannot have authority to examine the primary power because it exists outside it, the referendum, questions relating to the referendum exercised in the secondary constituent sense are examinable by the court. Quickly, we then move to how the sovereignty, the concept of sovereignty, reveals in the Constitution. And we have provided two articles, Dietmar Green and Daniel Lee, in our bundle of authorities. Dietmar Green explains sovereignty, political rule, legal rule. Daniel Lee explains sovereignty as popular sovereignty. Popular sovereignty means this, that sovereignty in the practical sense is channeled through constitution, through constituted organs. So sovereignty can be channeled through the judiciary, the executive, parliament, and that is bona fide power exercised for the people. So when the judiciary exercises sovereignty delegated to it by the people, it acts bona fide. And the same is true for the IEBC, that at Article 249, one is expected to express sovereignty on behalf of the people. And let this message be clear out there, that the IEBC is an independent, bona fide recipient of the the sovereign power of the people, and only responds to the people, and acts in authority as granted by the Constitution to nobody else. Quickly, I move to the authority of the court. There's a growing habit in this country. Senior Counsel James Orengo made an allegory of Jezebel. Jezebels in this country have had the habit of every time judicial officers make judicial decisions in accordance with the Constitution, the Jezebels will go call judicial officers names, deprecate their image, all in the name and in the belief that the judiciary is a lesser branch of government, that the elected branches purportedly have higher status than the judiciary. What is the authority of the High Court and indeed the judiciary under the Constitution? We have established already that the judiciary is a direct beneficiary of sovereign authority. That is not controvertible. The Constitution enables the court to be a situation, a site for sovereignty of the people. Chapter 10, Article 159(1) employs the term vests. This term vests was only used in the Constitution in reference to the judiciary and to the legislature at Article 94(1). Ask yourself, when it comes to the executive, the term vest is not used. What is the message that the drafters of the Constitution were sending to us? And what does the term vest mean? The term vests under the Black's Law Dictionary refers to this: conferring ownership, to invest in a person, full title or property. It can also mean an immediate fixed right. So, ladies and gentlemen, the Honorable Court, the judiciary is vested with property. You are agents of the people, and you have to speak the constitutional truth without fear, favor, or feeling intimidated. You are bona fide claimants of sovereign authority. The High Court, as structured in the Constitution, loosely adopts what is called the Kelsenian court in conceptual theory. Professor Gidu Muigai submitted here that the High Court engaged in lofty theory. Theory in constitutional law is part of the footstools, the African stool. Theory is one of the footstools that anchors the law. The law is anchored on the who, the what, the why. The who, substantive law. The what, substantive law. The why, theoretical law. The how, procedural law. So theory. The Constitutional Court, Kelsenian Court as it is commonly called, is a product of histories around the world. The Kelsenian Court, such as our loose model in Kenya, is equipped with a special unique power, the power of judicial review. And that power is ably pronounced at Article 165(3). And that is the authority that the court claimed when it examined the substantive values of the Constitution in the impugned bill and the procedural steps. Because the court is empowered to examine substantive questions, the value questions, and the procedural steps, the procedural values of the Constitution. And Article 165(3)(d)(2) I hope I'm correct. Any threat to the Constitution is enough to invoke the authority of the Kelsenian court, as the High Court did, in drawing from the sovereign authority it receives from the people. The High Court exercised bona fide authority. That is the authority granted to it under the Constitution. And therefore, it is demeaning, it is a tad arrogant to cast aspersion on judicial offices, to demean the image and integrity of courts for specifically doing what is decreed and declared in the Constitution. We submit a Kelsenian court, the High Court, enjoying the Kelsenian prominence loosely as it is in the Constitution, is a bona fide recipient of sovereign authority from the people of Kenya. Quickly, I move to public participation in the context of constituency and boundary delimitation. We have provided material in our bundle of authorities at page 428 to 429, and this is a scholarly article by Professor Tina Nabachi and Matt Liniger, Public Participation for the 21st Century. A lot has been said about public participation, but this was not said. Public participation enjoys its pride of place at Article 10. And Article 10 deals with principles and or values of the Constitution. Now, what is public participation? This is our submission, that public participation is a differentiated power track. What do I mean by a differentiated power track? It is authority belonging to the people, sui generis, and must be exercised in its quantitative and qualitative sense, and that is without apology. Public participation simply denotes that the people, in their sovereign superiority, must influence, must have input in important matters of their governance. Public participation in the context of constituency boundary delimitation ought to have led to the question with regards to Article 89(1). Do we keep the constituencies at 290, or do we reduce them? We are burdened by loans taken from all over. The burden is too much for us. Can we reduce the number of constituencies? That is a question that the people of Kenya should have borne, if the question was posed to them. The people of Kenya, in their madness or cleverness, could also have decided to increase the number to 400. That question was not posed to them. And we have submitted that public participation in the context of boundary review and delimitation did not happen. Telepathically, I can hear a question that he who proves, he who alleges must prove. My senior Elisha Ngoya addressed the commonsensical and the legal bits of it through the Election Act. I want to answer it in the political sense and drawing from authority from this court. In the political sense, being that we are citizens and not subjects. The citizens of Kenya, Nafula from Trans Nzoia, Mwekali from Machakos, Auma from Uyomararieda, Wajiko from Nyeri, ought to have been asked about whether they want to increase or decrease the constituencies under Article 89(1). So we allege that did not happen. Now, to those who will tell us that since we are alleging we have to prove that public participation did not happen, allow me to refer you to an authority of this court, Civil Appeal number 6 of 2018, the case of Kesi Jindwa Karuku versus steelmakers. This court said that a negative inference such as we are making cannot be on us to prove. It is for those we are citing that negative inference to certify this court that indeed public participation did happen. It did not. As I wind up, and in conclusion, one Kenyan who unfortunately demised, and Kenyans quite clearly remember him, the late senator for Mutembei, one Gerald Otieno Kajwang, contributing to the Bomas Revolution Committee, said this: "We are the people. We must disperse power. We must share resources. We have to spread power horizontally and vertically." Quite animated as he was, that is the message of this constitution. Power has to be deconcentrated from the center. The people have to have their share of power as they envisaged under the constitution. Public participation being one track of authority as we declared and decreed unto ourselves. Another Gabriel, and this is Gabriel de Riquetti Comte de Mirabeau. This is a French legislator in the context of the ousting of King Louis XVI, a despot par excellence during the French Revolution. Told this to the military guards who were sent to come and disrupt the Constituent Assembly. I will say it in French and I will translate it in English. Allez dire au roi que nous sommes ici par la volonté du peuple et que nous n'en sortirons que la force du baïonnette. For those who don't understand French, basically what Gabriel de Riquetti Comte de Mirabeau said is this: that go tell your master, your king, that we are here by the will of the people and we will only be forced out by the force of the bayonet. That's an exhortation for this honorable court. Mudomi Thiankolu, addressing you yesterday, told you not to drop the sword. When that sword was dropped, we had the radical surgery where judicial officers were treated inhumanely and demeaned for extraneous reasons. The tenure of the judges was removed for extraneous reasons. The constitution was reduced to blanket piece of papers. Gazeti tu ya kusoma. That is what we hear them say. This constitution represents the solemn will of the people of Kenya. This constitution was inked in blood. This is a product of a constitutional moment. 2007, when people died, killed, mercilessly butchered. That led to this constitution being and coming into life. It cannot be, as has been suggested from other quarters, that this is an elite pact. Hell no. This is a product of blood and sweat of ordinary Kenyans. I end by saying this to the Honorable Court and in echoing the words of a very noble son of Africa, Deputy Chief Justice Emeritus of South Africa, an admirable man, Digang Moseneke, the courage of principle. You have to have courage. The principle is in this constitution. Take fortitude in what it says. Courage, principle, adherence to our constitutional pre-commitments. Those are the only saving lines for us not to drop the sword. The insults will come, the calumny will come, the indignity will come, But to you and for the people of Kenya, it behoves you to do one and one only thing: pre-commitment to the Constitution, and that alone will suffice. I submit. Thank you.
Thank you, Council. Who's next?
May it please the court. My name is Kevin Doho Masharia. I appear with Edgar Busiega for the...
Is it Kevin Macharia?
Yes, Kevin Doho Masharia. I appear with Edgar Busiega for the Kenya National Union of Nurses. Our petition in the lower court was petition number 397.
Sorry, you say you appear together with Mr. Busiega?
Yes, Edgar Busiega.
And remember we're given 15 minutes.
Yes,
Thank you.
yes, I'll try.
Thank you.
Because of the little time, the 15 minutes, I'll just highlight the documents,
yes.
And Mr. Busiega will highlight the cross appeal and the issues arising out of the betrayal of the legitimate expectation of healthcare workers. We filed a notice of address and a notice of cross appeal.
Council, can you try and raise your voice, please?
Yes. We filed a notice of address and a notice of cross appeal dated 8th June 2021. We then filed submissions dated 9th June 2021, a list and digest of authorities dated 27th June 2021, plus additions in volumes A, B, and C. Then we relied on the petition and submissions from the lower court found on the BBI record from pages 1257 to 1353, and our issues in the lower court judgment were addressed from paragraphs 620 to paragraphs 632. We had annexures which are found on volume 3, paragraphs page 1313 of the BBI record of appeal, and the gazette notices at volume 4 of the BBI record of appeal at between pages 1574 and 1576. The position of our client is we oppose the BBI bill only as far as it excluded the Independent Health Commission as found to be found as a constitutional amendment. I'll give a few comments before I sit down. On the basic structure, we submit that the Constitution does not contemplate eternity clauses. We rely on an authority called Dead Hand Constitutionalism, Honduras, and the danger...
Counsel,
yes.
Let me understand you. You are, other than for the part where yes, the learned judges did not agree that you ought to have been included in the amendments.
Yes.
In actual fact, you are actually opposed. No, you are supporting the appeals.
Yes, somehow.
What do you mean somehow?
Because when we want that health commission, the Constitution must be amended to include the interests of the health. I'm looking at
your prayers.
Yes.
Your prayers are at page 2 of your notice of cross appeal, and you are saying that you want the judgment delivered on 13th to be set aside, the entire judgment be set aside, and
the petition to be allowed.
And your petition be allowed.
Yes. That's as far as we go.
So
that's as far as our submissions go.
So you are supporting the appeals.
We are sui generis litigants. We only have one issue to prosecute and find a way to find the interests of our clients provided for.
So perhaps don't go into the basic structure and such other things. Just go straight to your issue of that you should have been included.
We have to, because if basic structure applies, our client will not have a way to get what they want.
Oh, okay.
Yes.
Sorry, how does then basic structure have to do with what Kenya National Union of Nurses want?
What we say,
one singular issue.
Yeah, what we say is this: the Constitution is amendable, and it can take into account the healthcare issues, especially the interests of our client. Because of the shortness of time, my colleague will deal with those issues. Yes, Mr. Busiaga.
And that's why, of course, it's too late now. Ideally, you should have come earlier to support this whole business of the appeal.
He'll deal with those issues, especially on that issue.
Just a moment, Council.
Yes.
That you should have come earlier. It's more sense for us, in terms of where our head is, what we are focusing on now. But
yes.
I guess it's your time.
Okay. From that aspect of what you're asking, we adopt our submissions and we ask that you give them credence to our prayers. And because of time, I just promised my colleague that I'll take 3 minutes. My 3 minutes are up. I rest.
Thank you, Your Lordships. My name is Edgar Busiaga, for the record. In the interest of time, I'll submit without necessarily referring to documents. Perhaps for the bench to understand the issue at hand and the position of the Kenya National Union of Nurses is that the Constitutional Amendment Bill of 2020 is opposed. Your Lordships, it is opposed to the extent that the nurses were not made part of the process. And what was choreographed as a public exercise in terms of seeking public views, in which the nurses presented their proposal, that proposal was ignored. Your Lordship, it was admitted in the first report, which is popularly known as the BBI report 2019. But subsequently, when the amendment bill came through, it was not part of it. To that extent, therefore, we oppose the Constitutional Amendment Bill and state that it is actually a legal fraud. A legal fraud in the sense that it does not represent the wishes of the people. My lords, the nurses were made to believe that this was a process towards uniting the whole country. And they went ahead and told people, bring your views. Now, we are being told, and that submission was made by Senior Counsel Otienda Molo, that the promoters of the bill are one Dennis Waweru and Junet Mohammed. The nurses feel cheated to the extent that the promoters of the bill, to the best of their knowledge, was the President of the Republic of Kenya. And since the nurses were willing to be part of building a country, they subjected themselves to this process. Along the way, it turned out to be a farce, not intended to achieve the will and wishes of the people, but as a vehicle to serve their own private interests. In this case, the interests of the President of the Republic of Kenya and his erstwhile foe and now friend and brother, Honorable Raila Amolo Odinga. To that extent, we oppose the Constitutional Amendment Bill. If the process had been initiated with the inclusion of the Health Service Commission, an independent health service commission, with the same status such as the Judicial Service Commission, the Teacher Service Commission, the nurses would have thought about it. The eminent submissions I've had is that the appellants want